Hey everyone, and welcome to this explainer. Today, we're diving deep to unpack the intricate and sometimes messy world of legislative competence. We're going to build out your ultimate constitutional toolkit so you can clearly understand exactly who has the power to make laws, where they can actually enforce them, and what specific subjects they're allowed to touch. Let's get right into it.
Now, what's absolutely brilliant about this quote is how Dr. Ambedkar perfectly frames our entire journey here. He reminds us that legislative power isn't just some gift handed down from the central government to the states. Not at all. It's a rigid, structural blueprint that is hardwired directly into the Constitution itself. The rules of this game are set by the ultimate law of the land.
All right, let's quickly look at our roadmap. We'll cover the foundations of legislative competence, the territorial nexus doctrine, resolving subject matter overlaps, repugnancy, residually, and colorable legislation, and finally, how to apply all this to ACE and essay question.
Section 1. Foundations of Legislative Competence, the Blueprint of Power. So, this right here is the absolute bedrock of Indian federalism. Basically, Article 245 draws the geographic borders. It allows Parliament to legislate for all of India, while state legislatures are strictly confined to their own state borders. Then, Article 246 comes in and divides the actual topics into three distinct lists. List I is strictly for the Union, List II is for the states, and List 3 is concurrent, which means both can play in that sandbox. On paper, it's a beautifully organized system, but as we'll see, reality gets a bit messy. Moving right along to Section 2, the territorial nexus doctrine, when state laws cross borders. Okay, so what actually happens when a state's law tries to reach beyond its own physical map? Well, the courts had to step in and develop the territorial nexus doctrine. This principle validates state laws that cross boundaries, but there's a huge catch. There has to be a genuine, undeniable link between the state and whatever it's trying to regulate. That connection must be real. It cannot just be some legal illusion. Let's put this into perspective with two completely contrasting cases. In Pompit Law Shaw, Madras tried to tax a sale that physically concluded way over in Calcutta, simply because the initial paperwork started in Madras. The court immediately said no, that link is way too weak and hypothetical. But then, look at the Charusila Dasi case. Bihar successfully regulated trust properties located entirely outside its state. Why? Because the core administration and the primary temples were inside Bihar, forming one integrated whole. That right there is what a real, sufficient territorial nexus looks like.
Which brings us to Section 3, resolving subject matter overlaps, navigating the gray areas.
When the subject of a law blurs those strict lines of the three constitutional lists we talked about, we have to rely on the doctrine of pith and substance. It's really just a fancy legal way of saying the heart of the matter. Basically, if a state makes a law that rightfully belongs on the state list, but it accidentally brushes up against a union list topic, this doctrine steps in to save it. It stops the law from being automatically thrown out over what is essentially a minor technical trespass. A perfect real-world example of this is the Bengal Moneylenders Act. It was challenged because it touched on promissory notes, which is a strictly federal subject. But the Privy Council looked at it and asked, what is the actual intent here? Its pith and substance was regulating local money lending to protect local borrowers. The fact that it encroached on federal territory was purely incidental, so the law survived. But what if pith and substance doesn't quite cut it? Well, that's when courts turn to the doctrine of harmonious construction. Instead of picking a winner and a loser, they actively try to harmonize the conflicting entries. Think of the Calcutta Gas Company case. The state list had an entry for gas and another separate entry for industries. By reading them harmoniously, the court decided that gas was simply a specific, deliberate carve-out from the broader category of industries, which allowed both rules to coexist perfectly. All right, Section 4, repugnancy. When laws clash, direct collisions on the concurrent list. So now we have to talk about the ultimate constitutional showdown. What happens when the union and a state make competing laws on the exact same subject? Under Article 254, if both legislations occupy an identical field on the concurrent list and they directly contradict each other, parliamentary law reigns supreme. The state law becomes completely void to the extent of the conflict. It's essentially the Constitution's built-in tiebreaker. But here's the catch. Just overlapping a little bit isn't enough to trigger this. In the M. Karunanidhi case, the courts laid out three very strict conditions for repugnancy. There has to be a direct, irreconcilable collision. Basically, if you can obey the state law without breaking the central law, there is no repugnancy. The two laws must be completely and utterly at odds with one another.
And you know what's fascinating? Parliament doesn't even need to formally repeal the state law to override it. Take the Zavarbai case, for example. Bombay had a law that punished food control violations with up to 7 years in prison. Later, Parliament passed a central law capping the penalty at 3 years for that exact same offense. Even though Parliament didn't explicitly say we are overriding Bombay, the court ruled it an implied repeal. The two penalties simply couldn't logically coexist.
Section 5. Residuality and colorable legislation. Catch-alls and fraud prevention.
So let's look at a couple of final constitutional safety nets. Article 248 is essentially the ultimate catch-all basket. If a new technology drops or a new type of tax emerges that the founders didn't think to put on a list, it automatically defaults to Parliament. The Dillon case proved exactly this point. It established that if a subject, like a wealth tax on agricultural land, isn't specifically blocked by the state list, Parliament holds the residuary power to tax it.
Then we have this brilliant concept called colorable legislation, which is all about preventing legislative trickery. The rule is simple. What cannot be done directly cannot be done indirectly. A legislature cannot just slap a false label on a law to trespass into forbidden territory. You absolutely can't disguise a union subject as a state subject just by giving it a clever title. The courts will look right past that label to see if it's a fraud on the Constitution.
The Ogden Mills case is honestly a fantastic reminder of how this plays out in the real world. Dealers were overcharging sales tax, so the state stepped in and forfeited that excess money. Naturally, the dealers cried foul. They claimed the state was secretly enacting a punitive confiscation disguised as a tax law, which would be classic colorable legislation. But the court disagreed. They looked at the true intent and ruled it was a valid regulatory mechanism to protect consumers, not some sneaky attempt to steal federal powers.
All right, Section 6, acing the essay question, applying the toolkit. Okay, it's time to turn all this dense theory into practical application. If you were presented with this exact question on an exam regarding the territorial nexus doctrine, you'd need to clearly explain the rule, break down the tests, and intelligently provide the relevant case law.
So to truly master this, and I mean jump from a solid B+ to that highly coveted O grade, you have to move way beyond just reciting facts. A basic analysis just quotes Article 245. A deeper analysis weaves in the Poppet Law Shaw and Charles Seal Dossie cases, making sure to clearly distinguish between hypothetical and real connections. But top-tier insight, that requires you to critically evaluate whether this doctrine actually fosters coherence in our federal system, or if it just creates messy ambiguities.